I clicked start recording. Welcome to Shinera's Risk Management Seminar on the Legal Liability of Design Professionals. While there are many different theories of liabilities there are a lot of different theories of liability. For design professionals, most claims are based upon contractual liability or tort liability, and that's what we're going to be addressing today. You're probably all familiar with contracts, and we'll look at that in a lot more detail. We'll look at what it takes to make a contract and how risks can be created and allocated and mitigated or avoided by the terms of a contract. For torts, all you really need to know right now is that a tort is a civil wrong. That's a violation of a private right, as opposed to a criminal wrong, which is the violation of a public right. We're going to also look at the who, what, why of legal actions and defenses available to design professionals, and we're going to look at how firm organization can be a factor in a firm's potential liability to others. Now, architects and engineers have many different liability exposures. That's why you carry several different types of insurance. Today, however, we're going to focus on your professional liability, not general liability, auto employment liability, etc. Those are different. We're going to talk about professional liability, which is liability stemming from the negligent performance of professional services. And keep in mind that for our professional liability insurance policy, the definition of professional services is very broad. It includes not only architects and engineers, but also land surveyors, interior designers, landscape architects, construction managers, lead green building consultants, scientists, and technical consultants. So it's very broad, and it really encompasses anybody who has that professional exposure. Reasons that you don't want to have liability claims against you is probably one of the biggest is damage to your firm's reputation, which can affect your ability to gain new clients and new projects. Sadly, when people are unhappy, they spread the news a lot faster than when they're satisfied. So you don't want to have damage to your reputation, which can also affect the loss of future business opportunities. Claims, of course, are a major consequence of professional liability, and they can include both insured and uninsured exposures. Uninsured exposures would include perhaps claims that come within your deductible. All professional liability insurance policies have a deductible. That deductible can range from perhaps $1,000 for a small firm up to $1 million for a larger firm or a very large firm. So that is all money that you as the firm would have to pay out before the professional liability insurance starts to kick in. And then, of course, there's also always the potential exposure for having a claim that exceeds the amount of coverage that you have. Or you may have some uninsurable exposures, and some of those we'll discuss a little bit later, what's insurable and what's not insurable. Loss of billable hours is a tremendous result of having a claim made against you. Time that you end up spending meeting with claims representatives and your attorneys, and perhaps having to sit through depositions or mediations or trials. A trial in a complex construction case can take weeks, if not months, and that's all time spent away from your practice. So it results in less time to get new clients and work on current projects. Civil reparations may include losing your license. It's rare, but it can happen. Some of you may remember the Kansas City Hyatt Regency claim that occurred in many years back. There was a Friday night, there was a tea dance, and there was a collapse inside the building, and many people were injured and killed. And although there were different allegations as to what occurred, one of the major problems did have to do with the structural engineer approving a submittal that was incorrect, and I believe that structural engineer eventually lost his license as a result of that. So it can happen. I included resolution without admission of liability. Keep in mind that most claims settle prior to litigation or arbitration, but they're still very time-consuming and very expensive just to get to that point. Defense costs typically exceed indemnity payments. So defense costs are the amount of money that we pay for your attorneys and expert witnesses and anything that we have to do in preparing the defense of your claim. What we refer to as indemnity payments are those payments that are made on your behalf for the damages that are alleged to have resulted from your negligence. Um, we often can be successful and have claims close with no indemnity payments, but we still could be paying hundreds of thousands of dollars in defense costs. I thought it would be interesting to kind of look at a chart that shows over a 10-year period how claims against our policyholders have been resolved. Um, if you look at this chart, you can see that the majority of claims are settled through negotiation and mediation. That's about 57%. And only about 6% are litigated. Those are cases that are result in a verdict by trial, either by a judge or a jury. And less than 1% are actually determined through arbitration. 20% settled during adjudication. What that means is that the lawsuit has been filed and probably you've gone through some discovery, depositions and requests for information and things like that. So there's been a lot of expenses made, but it got settled prior to going to an adjudicated verdict, meaning that it was not heard by a judge or a jury or an arbitrator. We like the fact that about 13% are dismissed. Those are in litigation, but we are able to convince the plaintiff that perhaps we have no liability or perhaps they're not able to find an expert witness to testify against us. And so we're able to obtain a dismissal. But again, there's a lot of costs that are incurred getting to that stage. So avoiding claims and disputes is probably one of the major goals. Now, there are two major theories of liability that create the most claims against design professionals. As I mentioned earlier, that's contract and tort. So let's start off by talking about contracts. We often say that a professional service agreement is your best risk management tool. I can promise you that if you have a claim, the first thing your claims person is going to ask for is to see a copy of your professional service agreement, to see what's in that agreement that's going to help them defend you, and conversely, what's in that agreement that they might look at and say, oh, we've got some problems, and it may result in having to settle faster than they would have liked or for more money than they or you would like. But if the terms of the contract are difficult, it may make it harder to defend you. From a risk management standpoint, I can tell you that very often when a claim comes in, when we get a question in the risk management department, questions such as, my client isn't paying me, can I stop providing services? Or my client wants my documents, do I have to give them to him? Or my client wants me to join in an arbitration between him and the contractor, do I have to agree to that? My answer invariably is, what does your contract say? Because if you have a good professional service agreement, it's going to address all these issues. And then you don't have to wonder if you can stop services and not get sued for delaying the project, or who owns the documents and what rights does the client have to them, whether you're still on the project or even terminated from the project. And dispute resolution, how is that going to be handled? Can you be joined in an arbitration with another party? Are there agreements to mediate prior to going to arbitration? All of that should be resolved before the issues come up. So I've put together another chart, and this shows over a 10-year period what types of contracts have been used in the claims that were reported to us that we handled. And it's, I guess, interesting to see that the majority of claims involved insured drafted contracts. So these are your own contracts that are hopefully protective of you and have been reviewed by your attorneys and perhaps by your brokers or your risk managers. And they should be somewhat protective. The next largest group, which is also good to see, are the AIA or EJCDC documents. These are what we refer to as the standard form agreements. We're big supporters of the standard form agreements because they're court tested and they're coordinated. So your agreement with the owner and your agreement with subconsultants and the owner's agreement with contractors or construction managers are all coordinated. And that's very important because when there's any ambiguity between the various contracts, the only party that really benefits from that are the attorneys. They get to fight it out. For those of you who may not know, I know a lot of you are familiar with AIA. EJCDC stands for the Engineers Joint Contract Documents Committee. So similar to the AIA documents, these are a set of documents that were created by the engineering community with input, again, from not just engineers, but owners, contractors, attorneys, insurance companies. Shinera sits on the document committee of both AIA and EJCDC. So there's a lot of different viewpoints that go into creating these documents. One of the things that I don't like to see on this chart is that 10% of the agreements that have been used on claims reported were oral agreements. Oral agreements means they're not put down on paper. They're kind of and we'll talk more about that as we progress into this webinar. But the problem with an oral agreement is you don't have anything in writing to back up what the promises are. And as you can see, 35% of oral agreements resulted in indemnity payments, which is 30% higher than the rate of paid claims for the average. So oral agreements, are not worth the paper they're written on, is the expression, and I truly believe in that. I strongly recommend you do not use an oral agreement, that you have something in writing. Okay. Why do we have professional service agreements? They accomplish these purposes. Basically, the parties can state the goals and expectations they have of each other and of third parties. They allocate rights and responsibilities, risk and reward. Written agreements can help the parties deal with future changes. Even though it may not be possible to determine exactly what those changes might be when you're negotiating the agreement, it's usually possible to establish some kind of process and procedures for dealing with change. Because as we all know, construction projects have many changes that occur and they have to be addressed. Contracts also can help prevent disputes and can establish a framework for the fair resolution of those that do occur. Now remember, 62% of claims against design professionals are made by your client. And if not by your direct client, then if you're a subconsultant, perhaps by your client's client. But that's a really important thing from a risk management standpoint, because if that's where the majority of claims are coming from, you should be able to manage your client's expectations and have a good bedside manner, establish a great relationship so that they trust you, and having all of that, communicating and documenting conversations with your client will all help resolve disputes before they become disputes. Some of this reminds me of having a good contract of a case study that I recently read for a claim that involved a state Department of Transportation that made an $800,000 claim against a civil engineer alleging unsafe guardrail design. The claim was impossible to settle because the engineer's contract with the Department of Transportation required that the DOT manager act as the arbitrator on any claim. So that's really fair, right? Your client makes a claim against you and they get to decide how much you owe them. So despite appeals to the court upheld the requirement, saying that the engineer knew that provision was in there when he signed the contract. The claim ended up settling for the engineer's policy limits, despite the engineer's defense that the DOT assumed full responsibility when it changed the engineer's design to a less expensive one. Remember that once you sign a contract, it's pretty likely that the courts are going to uphold the terms of that contract, even if they seem unfair to you. The courts don't really care about fairness. Their attitude is that you had a choice. You could either negotiate changes or walk away from it and not sign it. But once you sign that contract, you're pretty much obligated to the terms of that contract, whether they're unfair or not. So it's very important to understand what's in your contract. Don't guess at what some terms mean. Remember that contracts are written by attorneys, mostly to be interpreted by other attorneys. And so we average people may assume that we know what something means, but there could be terminology in there. For example, things like time is of the essence, which just sounds like, oh, time is important. Okay, that makes sense. But having that phrase in your contract may make the schedule the most important thing, so that any slippage of that schedule could result in a claim against you or even possibly termination of the contract. So if you have any questions about what a contract means, get help from somebody, from your broker, from us, from your attorney, from whomever. So I thought it'd be good to talk a little bit about what makes contracts legally viable. Not all contracts are legally viable. They have to have these 4 elements. The first one is mutual assent. This is basically offer and acceptance. And that's one of the problems when you have an oral agreement or an incomplete unsigned agreement. There's no proof that you had mutual assent. So let's take an example where perhaps you're meeting with a client. You send a contract to the client, you start working on a project, but the contract's not been signed. Is there acceptance? No, there isn't. What if the client starts paying you? Then is there acceptance? Maybe. Or as I like to say, the answer I hear from a lot of attorneys when I ask questions is often the answer is often it depends. Some attorneys will argue that that created acceptance, and others on the other side may say no because there's still no signed agreement. What if you even receive an email that says, I accept? Is that acceptance? Again, maybe, or it depends. Some attorneys might argue that there's no proof as to who sent the email. They could argue that somebody else sent it. The best evidence of mutual assent is a signed contract. Otherwise, a lot of time is spent and money on attorneys. And this is something that's not often taken seriously by a lot of design firms. I urge you to get the signature as quickly as you can. Say you can't start working on the services until it's received. It's that important. As a matter of fact, as I think I'm aware, California may be the only state that there's actually a law in California on the books, a statute that says that you should not be working on a project unless you have a signed agreement. There are some exceptions to that, of course, but they're still very long and involved. And the bottom line is if you have a fee dispute against your client, for example, in California, and you go into court and you don't have a signed agreement, they would probably throw that out and might not ever get your fees. So please get a signed agreement. Now there has to be consideration. That's the second element. That's the motive for the contract, the bargain for exchange of something of legal value. Promises are also good consideration. One party may promise to perform services in exchange for the other parties to pay. That's valid consideration. Remember, fee disputes can lead to claims. If you're not getting paid by your client, the first thing I would suggest is finding out from your client why they're not paying you. Is it that they're having financial difficulties? That's one issue that you have to deal with. Or is it because they're unhappy with your services? Better to know that sooner than later, and as soon as you know it, to start addressing that issue. One thing I've learned when I used to handle claims is that probably, 85-90% of the time, if a design firm filed a claim against or a lawsuit against their client for fees, that was going to result in a counterclaim from the client saying, well, the reason we didn't pay you was because you were negligent, your services were inadequate or ambiguous or whatever or delayed us or whatever the allegations may be, and then you're off and running. So it's very important to try to avoid having fee disputes in the first place. Stay on top of being paid and address the issue if you're not getting paid. Legal capacity. In most states, that's 18. It assumes a comprehension of the agreement that you're entering into and that you have the authority to bind the contract. And this can be an issue involving licensing as well. Since all states require that design professionals be licensed in the state before practicing there, a design professional who's not properly licensed may be denied access to the courts in that state to enforce a contract if that should ever be necessary. And then, of course, let me just say, therefore, to the extent that an unenforceable contract is no contract at all, proper state licensure is also a component of a party's legal capacity to contract. And then lastly, legally permissible objective. You can't enter into a contract that violates current laws or statutes. That's not a viable contract. There are different types of contracts. There are express contracts, and this is when the parties speak or write the term. What's a little confusing is that not all express contracts have to be in writing. Oral contracts are express contracts and can be legally enforceable. Then there's also implied contracts, where a promise can be inferred from the conduct of the parties as opposed to their express words. It's inferred from behavior, not a signed agreement, but let's say the client starts paying your invoices. There's an assumption that there's an implied contract, and that can be risky. That can lead to questions such as, let's say a client says to you, please design a new deck for my house by next week and I'll pay you $1,000. You don't say anything and you don't offer a contract, but you produce the deck design within the week. Did you have a valid contract with a client? Yeah, I would say you did. The law would infer that your actions created acceptance of the offer and a contract existed, and therefore the client would be obligated to pay the $1,000. In another situation, let's say the client never signed your professional service agreement, but you began working on the project. You sent an invoice to the client, which the client paid. Then did the design professional or did you have a valid contract with the client? Yes, I believe the law would infer acceptance of the agreement because of the client's payment. But you can see that between the issue of implied versus express contracts and the issue of offer and acceptance, there's a lot of room for attorneys to make a lot of money if things aren't done cleanly by having a signed agreement in advance of doing all of this. So really, why do that? Try to make it as easy as possible early on. And we address contracts in just about every seminar we conduct because we think it's that important. It is the number one risk management tool. Believe me when I say that all defense attorneys and all claims people hope you have a signed, well-drafted contract in place if you have a claim. So now we're going to move on from contracts to torts. And what a tort is a civil wrong that violates the personal, business, or property interests of private citizens. And there are several different types of torts to know about. There's negligence, which creates the most claims against design professionals. And that's the focus of today, really the heart of what's covered by professional liability insurance. But there are also intentional torts and strict liability, and you should be aware of those exposures and how you might be creating those exposures for your firm. So let's start off by talking about what is negligence. And this applies to all situations, not just being a design professional. Negligence is basically you have a duty and you breach that duty. If you breach the duty, that's negligence. And then if that breach of the duty causes damages, you have legal liability. This is kind of law school 101. So we're going to talk a little bit from a term of, for design professionals, how are duties created? And duties can be created by under common law, by contract, or by statutory requirements. So under common law, that's what we refer to as the law of the courts. When you hear attorneys go into court and cite prior cases that came before, Jones versus Smith, that's the law that was established under common law. And under every jurisdiction in the United States, common law states that a design professional's duty and obligation to their client is to meet the professional standard of care. And that's typically defined as doing what another design professional practicing in the similar discipline at the same time in the same location on a similar project would have done. If you breach that standard of care, you're considered negligent. And of course, not coincidentally, professional liability insurance really provides coverage only for your negligence in providing professional services. It does not provide coverage for your contractual obligations, what we talked about earlier, which is another way of creating a duty could be by your contract. Instead of being the law of the courts, we refer to that as the law of the project. That is what you and the client agree to. Now, ideally, your professional service agreement should only obligate you to meet your common law obligations, to promise that you will perform in a non-negligent manner, and that if you are negligent, you'll owe damages to your client. But unfortunately, typically we see contracts that expand your legal obligation to beyond what is obligated by common law. So if you agree to things like the highest standard of care, that may increase the standard of care to one of perfection. If I'm a client and I get you to agree to meet the highest professional standard of care, that's, anything goes wrong on that project and it's a gotcha. I can say, well, obviously you weren't perfect. You didn't meet the highest standard of care. You owe me damages. But that's not covered by insurance because insurance covers you for negligence, which is based on an ordinary standard of care, or a professional standard of care might be a nicer way from a marketing standpoint to say that to your client. Duties can also be created statutorily. There are codes that you have to comply with, for example, or statutorily, statutes might say that even if you weren't responsible, if an employee of yours is injured on a job site, you owe them their medical, lost wages and medical expenses under workers' compensation laws. So that's a statutory obligation that you may have a duty in that regard. So here's an example of a case study that we looked at one time that involved an architect who entered into a contract with a school district that required performance of the highest professional standards. Unforeseen conditions resulted in project delays, a very typical claim. Claims from contractors for delays and extra costs contributed to the $1.8 million claim by the school district against the architect. The contractual obligation to meet the highest standards made it difficult to defend the allegations. The highest standard is perfection, and as a result, the architect ended up having to pay $400,000 to settle the claim despite having no responsibility for the delays. Defense counsel says it's almost impossible to defend against that allegation. Now let's get back to the standard of negligence of you have a duty, and if you breach that duty, there has to be causation of damages. Think of this in terms of this, as I said, this can apply to everything, not just professional liability. When you're driving your car, if you come to an intersection with four stop signs, a four-way intersection, you have an obligation to stop before you enter the intersection. If you don't stop, you've breached your duty. If you're very lucky and there was nobody in the intersection at the time, well, then you don't have any legal liability because you didn't cause damages. But if you do broadside another car and you injure the people in the car and you damage the car, then you have legal liability. So the important thing in this is to try to remember from a professional liability standpoint that as much as possible, you want to limit your duties to your clients to what is required under common law, what is insurable, and what you have control over. And we'll look at in ways of some things that are not perhaps covered by insurance. Things like warranties and guarantees. The law does not require a design professional to warrant or guarantee either your professional services or the work of the contractor. You may have a client who insists that you do so in a contract, and if you sign that contract, you do have an obligation to them to warrant your services, but it's something that wouldn't be covered by insurance. Okay, in addition to negligence, other types of torts include intentional torts and strict liability. So now let's talk a little bit about intentional torts. And of course, there's three different kinds of those: deliberate misrepresentation, defamation, and intentional interference with business or contractual relationships. So what is deliberate misrepresentation? That's an example of that would be if you misrepresent your experience or your ability, or even perhaps that you're licensed. If you're a firm that's doing business in several different states, you want to make sure that your people who are working on that project are licensed in the states in which the projects are located. As an example, an engineer might intentionally provide a client with incorrect data about a projected performance of a new design for a processing facility because they want to get awarded the commission. The engineer could be liable for intentional misrepresentation if the client relies on this material fact when selecting that engineer and then ends up suffering damage because of the inadequate design. And would that be covered by insurance? No, probably not, because it's deliberate misrepresentation. There are exclusions for that. Now, if the representation had not been made knowingly, but it was incorrect because the engineer didn't reasonably investigate to determine its truth, then that would not have been intentional misrepresentation. It might be negligent misrepresentation. And negligent misrepresentation probably would be covered by your insurance, again, depending on how they word the allegations. Defamation is when a firm or a person is held up to scorn or ridicule. That can be libel or slander. You've probably heard of that. Libel is when it's written, and slander is when it's spoken. And architects and engineers have exposure for this, especially on job sites regarding contractors. If you make an uncomplimentary comment to a newspaper about the quality of a construction contractor's work, you might be sued by the contractor for libel. Now, fortunately, truth is a defense to defamation claims, and you may be found not to be libelous, but nevertheless, those kind of claims, again, can be very time-consuming and very expensive to defend. So you want to be careful what you say about the other stakeholders on a project. You don't want to interfere with that relationship also, because that's another intentional interference with business relationships. You don't want to interfere with the relationship between the owner and the contractor. And you certainly don't want to, for example, recommend that an owner terminate an existing contract with another architect or engineer just so you can get the work. That would definitely lead to a lawsuit. And then lastly, we have strict liability, which is liability without fault or negligence. This typically applies to manufacturing and product liability, not really to professional services. You may think you don't have this exposure, but perhaps if you do environmental work and you transport hazardous material, that could be considered a strict liability exposure. Um, Strict liability could apply to hazardous material, to explosives, to dangerous animals. Probably less likely you'd be involved with that. But again, to avoid that, and many of the contracts that I review, it refers to strict liability against a design professional. You want to make it clear in your contract that you're providing a professional service. You're not providing a product. You're not providing work with a capital W. Um, you want to keep that agreement limited to negligence. But it's important to be aware that these exposures exist and that you could be held responsible for something other than just negligence. So, to whom are design professionals responsible? For whom are they liable, and for what damages are design professionals liable, and what defenses do you have? Now, to whom you might be responsible will depend upon whether it's liability in contract or your liability in tort. So, liability according to your contract, you're liable to the party, obviously, with whom you have the contract. Um, but you might also be held liable to what's known as third party beneficiaries. And contractors sometimes claim to be third party beneficiaries, especially with respect to construction contract administration services. Can you be, can you be responsible to two parties at the same time? It's difficult to serve two masters, to to owe a duty to the owner and also to the contractor. So you really want to avoid that type of relationship. And it's important to know that the AIA and the EJCDC documents that I referred to earlier specifically disclaim any intention to create a fiduciary relation. I'm sorry, a third-party beneficiary. Um, there's a lot of good language in those standard form agreements, which is another reason that we so highly recommend using them. There's also language in those agreements that says that the contract can't be assigned to another party without each party agreeing to that, a mutual waiver of assignment without, just by one party. You spend a lot of time hopefully investigating who your client is and deciding that you want to work for that client, that, you've looked at their background, they are financially stable, they are reputable, they don't have a litigious background, they're experienced on these projects. I mean, you hopefully have done all that work. You don't want that client to suddenly be in a position where their contract allows them to give your contract to some other party. And now you're working for a client that you don't know anything about. So you want to also have a contract that keeps you from having exposure to parties that you don't know. Then there's liability in tort, and that's much greater. I mean, that can be liability to anyone to whom you owe a duty. And they're very jurisdictional specific, but it can apply to clients, the public, contractors, subcontractors, laborers, insurers, sureties, and even lenders. Some states even include foreseeable users. For example, condominium owners or the homeowners association. Even though your agreement is with the developer, you have no relationship with the homeowners or the homeowners association. But depending on the jurisdiction that the project is located in, you might still have legal liability to them. Another big difference, depending on jurisdiction, has to do with something called privity of contract. In some states, you would only owe certain types of damages to parties with whom you have a contract, and in other states that doesn't apply. It also can change depending on the damages that they're looking for. There's something called the economic loss doctrine that prevents contractors from filing claims directly against design professionals. Most states have done away with it, but it still applies. You have to know which state you're working in. I think honestly it doesn't really matter that much about that, because if Either the contractor can make a claim directly against you for things like delays and extra costs, or if they're not allowed in that state, they would make the claim against the owner, saying we were delayed and we had extra costs and it was all because of the design professionals. The drawings were ambiguous or were wrong, and there were delays in the way they responded to us on RFIs, and therefore we want them to pay these damages. And the owner would just turn around to the design professional and make the claim that way, so it would flow down to you. For whom are design professionals liable? Well, obviously, design professionals are liable for their own personal actions, but you're also responsible for employees under something called agency law. So as long as your employee is providing a service within their scope of their employment with you, you would be responsible for them. That's under something called the doctrine of respondeat superior. Basically, the master is responsible for the actions of the servants. And this can lead to some interesting issues sometimes if you have an employee who's perhaps moonlighting. So they're not really providing services within the scope of their employment with you. They've decided for whatever reason they're going to work for a neighbor or for an organization that they do volunteer work, whether they're getting paid or not. But you might not have known anything about it. They're moonlighting. But probably they don't have insurance in place should their negligence cause any damages on that project for which they're moonlighting. So we've often, we occasionally, I wouldn't say often, we occasionally do see instances where the owner of that project is desperate to have some insurance pay for those damages. Since the employee doesn't have any, they might try to make an argument that even though they might be moonlighting, that you were aware of it. You were aware of the moonlighting activities because perhaps the employee was using your equipment to do some of the project or took calls in the office and did spend some of their time when they should have been working for you, working on this moonlighting project. So you want to have a clear moonlighting policy in place in your office to make it clear that either moonlighting is forbidden altogether, or I've seen some firms who might have a form filled out so that if an employee does want to moonlight, the client of that moonlighting employee signs a waiver saying that they were aware that this employee is doing it on their own, not as an employee of your firm. Okay, design professionals also have legal responsibility for their consultants under a theory called vicarious liability. In a typical situation might be that you as the prime designer have signed a contract with the owner to design a project, and there's a problem with the mechanical issues. So in an ideal world, the client is going to make a claim against you because you're the one that they have a contract with and that's responsible. But you might turn around to the mechanical engineer and say, this was your negligence, report this to your insurance company and pay for these damages. And in an ideal world, that would happen. But occasionally that mechanical engineer may say, I no longer carry professional liability insurance. Or, well, I had professional liability insurance, but I'm such a bad mechanical engineer that I've had so many claims against me, there's no policy limits left. So I don't have any money and I can't pay that. Well, when that happens, who ends up having to pay the damages to the client? It's the prime designer, because you're in that middle situation. You've got the responsibility and the agreement with the client. So it is very, very important when you retain consultants that you first of all make sure that they have adequate insurance in place. There's no guarantee when you hire them that they're going to have insurance in place when a claim comes in, but you at least need to ask for certificates of insurance on an annual basis to make sure they're continuing to carry the insurance. And you want to make sure they've carried it in the past, because that's often a good indication that they're going to continue to carry insurance into the future. You want to obviously investigate them to make sure that they're experienced and knowledgeable and they have a good reputation and experience with the project type and all of that, so that anything you can do to try to reduce the exposure to your vicarious liability. And we have some excellent claim studies on vicarious liability claims of retaining subconsultants, and a lot of information that we can offer to you to help evaluate subconsultants. Another issue that we sometimes see when you hire subconsultants is the contracts have to be coordinated. I would strongly recommend not allowing your subconsultant, for example, to limit their liability to you unless you have a corresponding limitation of liability with your client. Because what can happen, and again, this is very state specific, it depends on the jurisdiction and whether they uphold statute limitations of liability in contracts, but I believe most states now are upholding those. So let's say again, this mechanical engineer had a claim and they did have insurance, but they had a limitation of liability on their contract with you that limited their liability. Let's do the standard one, $50,000 or the amount of the fees, whichever is greater. And their fees were less than $50,000. So they might say to you, yes, we know we're responsible, but we have this limitation of liability clause in our contract with you, so we're willing to pay you $50,000, but no more than that. And the claim might have been $250,000. Well, again, who's going to be stuck paying that extra $200,000 to the client? It's going to be you as the prime designer. And so you don't want to be in a position where you contractually limit your subconsultant, but you don't have any kind of limitation with your client. And that could even result in issues of insurability. It's just a bad road to go down. So you want to make sure that all of your agreements and the subconsulting agreements are coordinated. Then lastly, you also are going to have responsibility for your partners and your joint ventures. So it's important that in your either a joint venture agreement or your partnership agreement, you spell out who's going to be responsible for what. How is liability going to be shared if there's a claim? What damages are design professionals liable? And the damage type depends on the theory of liability that's alleged. But basically, there are three types of damages. There's what we call direct damages, and that's, for example, bodily injury or property damage. You design an office building and a manufacturing plant or whatever, and the roof starts leaking. The direct damages there would be the cost of repairing the roof so that it no longer leaks. Then there are consequential damages, and these can be typically much larger than the direct damages. And the examples of a consequential damage would be in the example I just said of a building that you designed where the roof was leaking. If that water damage then just damaged some inventory that was in the building or delayed the opening of a retail store, those are examples of consequential damages. For example, you're designing a school and it needs to open in time in September, in time for classes to begin. If there are if for whatever reason the school is unable to because of problems with your design, and the school has to go out and rent temporary classrooms, and the cost of all of that could be consequential damages. So it could include loss of rents, loss of financing, and it's hard to manage these kind of risks because they're so unknown. So one way to try to manage the risk of consequential damage is to obtain a mutual waiver of consequential damage in your agreement with your client. And again, the standard form agreements contain such a mutual waiver. Now, I've had some design professionals say to me, well, I don't want to waive my consequential damages against the client. That could put me in trouble. But really, design professionals rarely have claims for consequential damages against your client. But it is not at all unusual for your client to have very large claims against you for consequential damages. Again, for delays and loss of rents and things like that. Then there can be statutory damages. These are damages that are prescribed by local laws of the jurisdiction, and they may be awarded even if a party doesn't suffer any actual damages. For example, this could apply to things like copyright infringement. Now, the good news is there are defenses to liability. Even sometimes if you're negligent, there are defenses that are going to help protect you. And one of the most important of those are various statutes of repose and statutes of limitations. Pretty much I can promise you that when you have a claim, especially if it's for a project that you worked on a while ago, the very first thing your claims person and or your attorney is going to want to look at is was the lawsuit filed in a timely manner, or are you somehow protected because of the statute of repose? Statutes of repose are a time period that typically run from the date of substantial completion of the project and can go out any number of years depending on the jurisdiction. I would say typically it's 6 to 10 years. I've seen some states with 20 years, and my understanding is that New York State has no statute of repose. So again, you need to know what the statutes are in the jurisdictions in which you're providing services. This could also have implications for your record keeping. How long do you need to keep records in each of those different jurisdictions? Also keep in mind that sometimes these statutes of repose don't apply to government entities or even to tribal nations, so they may be able to bring a claim against you for a longer time than a private client. So I keep reiterating the importance of having local legal counsel to talk to you and make sure you understand all of these different laws, limitations of liability, statutes of repose, all of that in the jurisdictions in which you're working. So the statute of repose is kind of what we refer to as the big box. That's the one that they're going to look at to see if this project was done 15 years ago and completed and you're in a state with a 10-year statute of repose, then your attorney is going to file a request for dismissal based on that the lawsuit wasn't filed in a timely manner. Now, within this big box, there's also another box that protects you, and that's what we call the statutes of limitations. And they, instead of running from the date of substantial completion, tend to run from the date that the damage was known or should have been known. And there are different laws that apply to these. In many states, there are different statutes of limitations for bodily injury as opposed to property damage. And some states even have different statutes of limitations for what are known as latent defects or patent defects. A patent defect is something that's open and obvious. If there's water damage and you can see the water damage inside the building and it's resulting in mold and the mold is growing, that's a patent defect, and you have a shorter period of time than a latent defect, which might be some kind of defect that's behind the walls and that you wouldn't know about. It might be a structural issue. So you have a longer period of time typically to file a lawsuit for damages that are latent as opposed to patent. So here's kind of an example of how a statute of repose might work with a statute of limitations. Let's say that you own a project that has several buildings in a state with a 10-year statute of repose and a 2-year statute of limitations. So you may have 10 years from the date of substantial completion to bring the claim, but if you notice a leak 3 years after substantial completion, the statute of limitations would require you to bring that claim within the next 2 years, right? And if you don't bring that claim in the 2 years, you're going to be barred from making that claim, even though you're still within the 10-year period. Now, let's say in the next year, you notice a leak in another building on that same project. Again, you're still within the 10-year statute of repose, but you're going to be required to bring that claim within that 2-year statute of limitation. So clients should be aware of how long they have to bring the lawsuit, and you need to be aware of how long you have exposure. I like looking at this graph because it kind of helps us understand when claims are typically made against design professionals. We've never really understood why states have such a long statute of repose. I don't really think it's necessary to have a 10-year statute. It would be beneficial to design firms to have a shorter statute of repose, but and various states legislatures are looking at that, but it's been a kind of controversial issue. If you look at this graph, you'll see that probably half the claims are made even before the project is substantially completed. And if you look at 5 years out, that would really achieve the same objective. 92% of claims against design firms were made 4 to 5 years after substantial completion. It doesn't go up very much between 5 years and 10 years. As a matter of fact, we always used to feel as a claims person that claims that were made closer to that 10-year mark, you have a lot more defenses because it's been a longer time since you've had any contact on that project. Very often those damages that result are because of things like lack of maintenance, not necessarily a design issue. So they tend to be more frivolous claims. I think the only time that we really see in states with 10-year statutes of repose where a lot of claims come in at between that 9.5 years and 10-year period are in condominium projects, because plaintiff attorneys who like to have condos as their clients recognize that the longer they wait after substantial completion, the more damage there probably will be. And a lot of that may be due to lack of maintenance by the homeowners association or by the individual homeowners, but they will go out and target um, various condo projects and knock on doors and ask people for a laundry list of problems that they have with their unit. And everybody always seems to have some problem with their unit. And then they put together that's almost like a class action lawsuit. So condos are kind of the exception to this. What are other defenses to liability? Comparative negligence and contributory negligence, which is somewhat related but vary by state. Some states have one or the other. Um, and this would comparative negligence looks at you and the other parties or multiple parties and works out proportionately who is responsible for what. These large, complex construction cases are rarely the fault. The negligence is rarely the fault of one person. Um, so the owner may be partially responsible, the contractor may be partially responsible, and if you're partially responsible, you would only owe technically, say, 30% of the damages if you're 30% at fault. Now, other states have what's known as contributory negligence, and in those states, if the plaintiff contributed, the damages are reduced by the amount that he or she can collect. Some states have a threshold. For example, if the plaintiff is 25% at fault, they can't collect anything. Some states it might be as low as 1%, and other states have a much higher limit. Again, you need to know what the laws are in your particular state. But these are two very helpful types of defenses to liability because you're not always 100% responsible for the harm. So you shouldn't be held 100% responsible for the damages. Another extremely beneficial defense to design firms is the concept of betterment, or what's sometimes called value added. Basically, it says that plaintiffs shouldn't be in a better position because of your negligence. They'll still have to pay for what they would have paid anyway. So an example might be if you're an architect and you designed a school project, but you negligently designed to include any doors in the project. I think we would all agree that that's negligence. A school should have front doors, classroom doors, gym doors, etc. So if you were negligent and you didn't design them, would it be right for you to be responsible for the cost of all those doors? It wouldn't be, because had you designed it in a non-negligent manner in the first place, the client still would have paid for the doors. So basically, betterment says that the client shouldn't be better off. They're still going to pay for what they would have, but betterment is always open to negotiation. And if there's an extra cost now because the doors weren't ordered early on when everything else was ordered, you're going to be responsible for that difference in the cost. Another typical example we use of betterment is if a structural engineer omits a beam in the ceiling, then you have to tear out the ceiling to install the beam and then fix the ceiling. Well, the client would have paid for the beam anyway, but the cost of tearing out the ceiling and repairing the ceiling would be something that the engineer would be responsible for. And there's always negotiation involved when you have an issue of betterment, but it is a very beneficial defense. There's also waiver and estoppel, which are somewhat related. Waiver is in writing or by behavior. For example, you might see this in the issue in your contract about ownership of your documents, where the client says, I want to own the documents and I want to do whatever I want to do with them after the project is completed, like I might want to use them on another project, but they at least agree to waive any claims against you for reuse of the documents if you're not involved with that. That's an example of waiver. An example of estoppel might be where a client tells an engineer that he doesn't need to visit the site on a particular day when the engineer otherwise would have done so. The client will then be estopped from suing the engineer for not observing construction activity that would otherwise have been observed. Another defense is immunity. This typically refers to sovereign immunity, where governmental entities have sovereign immunity. Nobody shall sue the king is basically what that comes down from. And sometimes if you're working for a governmental agency, in some situations, their immunity may flow down to you. So civil engineers in some states who work on highways, as an example, may have the same immunity as your client. Again, you need to know whether you're in one of those states or not, because one of the things we see with highway claims very often is an accident may be caused by a drunk driver speeding and having, intoxicated and having no insurance, and various people are injured or killed. And in some situations, so they can't go after the driver of the car because he has no insurance and no assets. In some cases, they may not be able to go after your client, the government entity, because they have immunity. And in states where you don't have that immunity, you might be the prime target because you're the only party that's still viable. Another example of immunity might be that if your agreement says that you're the decider of disputes between the client and the construction contractor during the construction phase, for example, the AIA and the EJCDC documents give you immunity from decisions that are made in good faith. So you might want to have that kind of immunity in your contract as well. And lastly, we're going to talk about how your liability exposure depends on your firm structure. So if you're a sole proprietor, that's where one person owns the firm. You may or may not have employees as well. Well, your assets are at risk in that situation. So sometimes it's recommended that you might want to put your personal assets in the name of your spouse or in a trust for your children, because you will have responsibility not just for the firm, but for your personal assets could be at risk as well. If you're in a partnership, you and your partners are going to share liability. It may be 50-50. It may be something different depending on your partnership agreement. But all partners are jointly and severally liable. And think about it, a joint venture is also a form of partnership. So if you're in a partnership or a joint venture and your partner or joint venturer can't be responsible financially for damages they may owe, the parties can look at you as well. So there's a little bit more risk there. Corporations are the most common. They're entities unto themselves. A party may sue you and the corporation, but the professional liability policy will respond equally to you and the corporation. Typically, claimants have no right to pursue the personal assets of individual shareholders, so there is some protection there. But keep in mind that this shield is for personal liability, from personal liabilities only for general business liabilities, not for professional liability. Licensed individuals cannot escape liability for your professional actions. So if you are a licensed engineer or architect or any other type of design professional and you sign or stamp or seal documents, you are going to still have professional liability. You're not going to be protected just because you're working for a corporation. There are limited liability partnerships, LLPs. They offer protections from some types of partnership liability. Typically, the partners are not liable for each other, but that varies greatly from state to state. So you should, again, know what the laws are. And there's a LLC, which is a limited liability company, similar to an LLP. It won't shield individuals from liability caused by their own negligence, but will protect other members from liabilities caused by another member's negligence. It provides members with protection from personal liability for things like company debt. And that is the end of our webinar. I wanted to end it with just a screenshot of our Shenero School of Risk Management, which hopefully you are familiar with. There's a ton of information in addition to the School of Risk Management, which will give you continuing education. There are claim studies and publications on a variety of topics and contract language, and of course, past webinars that you can now listen to and review for continuing education. So thank you very much for your time, and thank you for joining us.